Hey, everybody. Welcome to the next episode of our clown show that we call the Justice Revolution. Is that getting old? Do I need to stop saying that? I'm just curious. I'm just
I
teasing.
think it's funny.
Okay, good. I just want to, me, I like to throw a little humor into things, get some people laughing. So, but anyway, I wanted to thank you all for joining us. I am your host, James the Patriot. Today is August the 11th in the year of our Lord 2023. I have my beautiful co-hosts with me, Erica and Justice. Say hello, ladies.
Hey, guys.
So Erica, as you guys know, hails from the great state of Indiana. Justice from just south of me up in the mountains here. Beautiful time of year here in the mountains. It's really pretty. Although we did have the dork in chief was in town the other day, and your entire city was shut down, wasn't it, Justice?
Yeah, that was an injustice.
Yeah, the pretender in chief, as we like to call him, right?
I just don't understand it. I don't get it.
I don't either. We're going to talk a little bit about some of the ridiculous things that happened while he was here or along those lines. So, but
sad.
It's just sad. But before we get to that, I want to say hello and welcome to my good friend and our guest, Brandon the Big Sib from the beautiful state of Louisiana. What's up, Mr. Brandon? How are you?
Thank you for having me today. Glad to be here. Hopefully we can open a few eyes and ears to understand our trajectory here and why everything is so hard fought.
Yes, it is. We're going to go over, we got a really good show today. I mean, I say that all the time because I'm biased. But I really feel like we do because we got an interesting ruling from a magistrate judge here on a case that involves a good friend of mine. We're going to go over that, her report and recommendation, and so on and so forth. But before we get to that, let's talk about some of the world events, some things that have happened recently. So some of you may have seen, or you may have seen in the news, that Biden was here in Utah earlier this week. And as a precursor to that, I don't know what this is, that there was an individual who lived south of me by about 2 hours, who was posting some online threats, making threats to take out Biden, which, as you guys know, you make threats like that, you're going to get some people looking at you. That's just how it is. All right. Yes, we have the right to free speech. Yes, we have the right to say what we want, but we also have to be responsible for what we say. And if it's a credible threat, you got to know the three-letter agencies are going to look at it. And I'm not talking about the female body inspectors. That's the other three-letter agency. Okay. So that agency, in my opinion, this is my opinion, and I want to get Brandon's thoughts on this too, but what they did is they executed a no-knock warrant on a 75-year-old man who was 300 plus pounds, needed a cane to walk, couldn't get out of his bed without help. Okay. They executed a no-knock warrant at 6:15 in the morning. I don't know all the details. The body camera footage hasn't come out. I don't think they're ever going to release it. Who knows? But at the end of the day, this three-letter agency shot and killed this man. So he's dead. Okay. That's where that is. Now, there's been a lot of speculation going on as to this or that and everything else. But what I'm gathering from this is, you make threats like this, you're good. They've moved beyond just showing up to your house and knocking on your door and saying, "Are you serious? Are you really going to do stuff like this?" They're going straight to the bust down your door, throw the warrant in your face. If you do anything that shows any kind of level of resistance, I don't know what resistance this guy put up, but they shot him and killed him. So
unless you're President Trump, because there's been a myriad of online death threats.
I mean, unless it's the other side, right? You have a well-known celebrity, and this picture has been all over the internet, holding up a severed head, a blood-covered severed head of President Trump, and nothing has taken place. So what I want to say to all of you who are watching or listening on the platforms that we are broadcasting on, you need to exercise due diligence and extra caution in everything you do. do not. I mean, I know our emotions get the best of us sometimes. I myself included. You say something off the cuff. You don't really think, you don't really mean you're going to follow through with that. It's just like, how many times have we just been upset and angry and say, you know what, say it again, I'm going to kill you, right? You're not really going to do that. Like I hear my 7-year-old, one of my twins, tell my other twin he's going to kill him all the time. Yeah, that's not going to. He's a 7-year-old, okay? But you guys need to understand, this is the craziness we're living under right now. And these people, the rule of law be damned. Due process of law be damned. You're going to see that today with the information we're covering. So, Brandon, did you see or did you hear about this story?
I did, and it's an unfortunate fact that we have people so hyper-polarized at this point in time that feel things are wrong and then act out in insane and illogical ways. But the truth is, most people aren't aware where we're really at in a time frame. We are in the midst of the largest culture war this country has ever seen. Well, and I'll go back, the second largest culture war leading up to the Civil War, and then the preceding years going all the way up until 1871, because in that time frame there, we also had what was called the Democratic Socialist Party, or what most people call it as the Ku Klux Klan. Yep. But they were a political terror group and were not what people think it is, a racist organization. They were the entire organization was fit to stop Republicans from passing laws and treaties that liberated people. So understand the cycle. But here we are again today in this man's instance, right? You cannot speak in this sort of way and talk openly like this. And of course, he was challenging them. There's other things that's come out on Twitter about him and things of that nature. But when you speak this way, you've allowed them to justify using deadly force because you're taking pictures of yourself with large ammunition and things of that nature, and even posted that he would kill the FBI if they showed up. This is not how things get done. So the other side are ideologues, first of all, and people must recognize this. In this culture war, they're going to use every trick in the book to obfuscate from the truth, and that means to shadow, darken. We cannot act in this way. Even a reactionary stance is never going to do you any good. You must be able to think through things through intelligently and act with moral and virtue, right?
Yes.
And when you do that, when you practice that, you won't make these slip ups. And I'll give everybody an example for me. I'm very much aware of the ESG Marxist ideology and the fascist ideation that is going on in this country today, where people are statist by religion, or the LGBTQ, PI plus, whatever religious ideology they're following is status in perfection, in actual how they perceive it. But when you do that, you have to be the opposite. So we're for individual liberty, right? So to say I'm going to kill somebody or I'm going to do this or that is actually a violation of our principles. And we should never violate those due to anger at any point in any time. We should always be able to speak intelligently and with always never move outside of our principle box. And what do I mean by that? So today, in the hyperpolarized camps of Trump, Biden, and everything else, right? People move their moral standards and their principles to fit within the narrative of their demagogue. And so demagoguery means a tyrant within government. And what they do is forfeit their individual critical thinking skills to fit within that narrative of their demagogue that they worship. This is morally bankrupt. It alleviates people for individual responsibility and personal accountability. Now, what really happened here with this man? Who knows? Will we get the body cam footage? Who knows? But yeah. It was a complete failure of judgment to post these things online in the time frame that we're in, when the FBI, CIA, and the modern administrative state is looking for justifications to hunt down quote unquote constitutionalists who are domestic terrorists. It's a bad look, and that's what they're going for. They must turn every single person in this country into a birth certificate sovereign citizen that actually challenges any of the tyrannical moves that they're making in this country.
Yeah, that's a great point. I mean, that's why I'm just saying, you know, over here in the chat here, destruction along the Little Deschutes River. I'm not sure who that is, but I love your name, by the way. In our Telegram chat in the Affidavits 101, he or she posted the video that a neighbor took that shows, again, you guys do your own research, draw your own conclusions, but this is what we're up against. And as Brandon knows, I mean, Brandon, how many cases are you litigating currently in federal court?
5.
He's got 5 cases he's litigating in federal court. Have you gotten any favorable rulings from any of those judges thus far?
Yeah. I mean, even with Maurice Hicks currently, the fact that he's ruling and I was able to put the notice of appeal in. I mean, if you're pushing COVID, property tax, things of that nature, and you're pushing it through the trial court, there's going to be one in probably 1,000 judges who aren't ideologically aligned with the viewpoint that more government's better, right? So,
Exactly.
And what do I mean? What do I mean by that? Let's get a framework here, Mike. The first part of this is to do evil in the first place. A person must actually believe they're doing good. Okay, so this is an ideology. Okay, a person's ideology is what they think, move, and act with. Okay, and this is what gives them the justification for doing what they're doing. So we must grasp and understand, first off, 99% of the judges, 99% of the attorneys, and 90% of the people accepted the tyrannical government of masking, vaccinations, and closed down every single one of their avenues. Okay, so now here comes you, standing in truth, standing in virtue, standing in morality, right? And what you're doing is casting a light towards these people that they screwed up. Well, here's the problem with that. Because in order for these people to continue on living, they've only got one of 2 choices. Either they must self-reflect and recognize their mistakes, or they double down into their ideology. Now, this is one of those things that people will self-deceive themselves to make their actions seem justified. Okay, and instead of hearing reproaches or curses, right? They want to receive honor and praise for doing the verbal virtuous thing. So when you're walking in that courtroom, you're not only challenging the status quo, you're challenging individual people who knowingly and willingly negligently violated the rights of the people. So if you think you're going to walk in there and it's going to be a cakewalk and that you're just going to blow right by them, no, that's not the case. We're dealing with ideologues. Okay. Right. And their entire worldview is wrapped up in trying to justify how they acted during COVID-19. Well, when you understand that, when you grasp that, you know that the picture is bigger. And for 5 of my cases, right, or 4 of my cases, which concern COVID-19, 2 of them are in the appellate court right now. In the Fifth Circuit, let's talk about good things. The Fifth Circuit's here in Missouri versus Biden. I don't know if anybody's been listening in on these deals with the judges grilling the government's lawyers who can't give an answer to why the restriction of the First Amendment through all these administrative agencies is constitutional. Then you have the FDA with a few other doctors that are challenged the constitutionality of the FDA, and then you have the CDC, all in the Fifth Circuit right now, and all doing very badly for the government. And this is the natural trajectory, right? So at this time, people are going to be screaming, wailing, gnashing of teeth. That's just what happens. And we've got the precedents already coming from the Supreme Court. And so it's a trickle down effect. But you have to stay steadfast. And this is where the rules and continuing. So let me give everybody a deal here. I forced the judge, Maurice Hicks, with a Rule 52 motion to identify the findings of fact and conclusions of law for why he denied my declaratory and injunctive relief and failed to apply the strict scrutiny standard to Shelley D. Dick's orders. Well, I thought this through. So there's standards of review. 2 standards of review are required through Rule 52. And that is, well, there's 3 standards of review, but I've got 2 of them covered. Okay. And those 2 are questions of fact or questions of law. And then the second one is abuse of discretion. So when the judge failed to give me the findings of fact as required by the civil rules of civil procedure, Rule 52, I get to appeal. So what have I done? I've set it up to where I can get to the Fifth Circuit and to some adults. And if the Fifth Circuit doesn't work, I get to take it to the Supreme Court for this injunctive and declaratory relief. And this is how you have to play it. For example, many of you are going to face 12B6 motions and 12B1 motions, right?
Mm-hmm.
So when they just sit there, we've got 3 summary judgments filed in 3 of the cases. Okay, for what? Why? Because if there's no genuine dispute of material fact, you force a judgment on the pleadings. Why are we doing that? That way we can, hey, look, the trial court judge is going to do what it wants to do anyway.
Yeah, they're going to deny. They're going to grant that motion anyway.
Well, that's right. Well, you force the hand to get a judgment on the pleadings. Let's get to the appellate court. Let's go ahead and go, because you've already got an abuse of discretion, especially in all of our cases have actual causes of action correctly pleaded, and there is no reason for any of the motions to dismiss to be passed. And that's failure to state a claim and a motion. All of them, none of them are valid. But you have to box them in while you're in the trial court and raise every issue. And people wonder why the Rule 52 motion was 50-something pages. What did I bring up in that Rule 52 motion? Every single possible issue that could be raised is in that motion.
Yes.
So guess what I get to do when I go to the appellate court? We get to review the entire thing. And people forget these simple ideas that if it's not raised while they're doing their motions to dismiss and everything else, you are to raise many different issues that apply to your case. So therefore, this leads into James's discussion today. Why is judicial activism so hard to bypass? Because judicial activism is based on quote unquote intent.
Yes.
Well, unfortunately, intent allows the individual judge to hypothesize and pontificate on the inner workings of what someone was thinking when they passed that statute, or in the case of the founding fathers, what they were thinking when they wrote the Constitution. However, that's not the avenue of law that we are teaching. The avenue of law that we are teaching is called originalism and textualism. That's right. That's right. And the statute itself, the rules of canonical interpretation, stipulate within the written words the limitations and exceptions to all rules. Okay.
Yes.
And so that is what is called judicial restraint.
Yes.
And when you're working it, you're going to find it's unfortunate truth. You're going to find more judicial activists than you are going to find judicial restraint. The problem with that is you must lock the judge in with the rules. And this is where Dr. Gray's course is really, really great, in that the rules do rule. However, you're not going to find that in every trial court, because one, the attorneys don't abide by them. The attorneys are going to always bring up stuff outside your pleadings. It's just going to happen. They're using the motions to dismiss as responsive pleadings, while at the same time claiming 12B1 and 12B6. And I'll give everybody and I'll shut up after this and let everybody else go. I'll give the lunacy of this. One of my cases has an actual EEOC charge from the Equal Opportunity Employment Center, right, out of Title VII of the 1964 Civil Rights Act. There's an actual charge written that the Civil Rights Act was violated, and yet I got a 12B1 motion to dismiss for failure to state a claim, right? Well, how do you get that when you've already got a claim from a federal agency saying that there's a cause of action here? But
Exactly.
it's they still did it anyway.
Yeah, this is the lunacy, and Brandon's hitting the nail on the head, you guys. And this is what I want everyone to know, because this is what is so difficult, right? I mean, I know we all learn these things differently. We all apply these things differently. But at the end of the day, when you look at just the foundation, and I want to keep this as simple as possible, and I'm going to tie this into a couple of things. So, as many of you know, earlier this week, I filed my property tax lawsuit against my county. I am still waiting for proof of service of process. I was told that was done on Wednesday, but here we are Friday. I haven't gotten it back from my process server yet. So, one of the things that I quoted in that suit, matter of fact, it's the very first line, and I copied and pasted from Article 1, Section 2 of the Utah Constitution, which states, all political power is inherent in the people and is in place for their equal protection and benefit. And I'm paraphrasing there. So when you tie things back and when you understand that no statute can supersede that, nothing that those 300 and something idiots in Congress do, that they put onto paper, that they all vote on, that they send to the president, that he signs, that cannot trump any of those, because those are natural rights, and those rights do not come from Congress. They don't come from a piece of paper. They come from God. But see, what Brandon's talking about is these attorneys, these lawyers, and even these judges, they don't want to talk about that. And you're going to see that today, because we're going to go over a couple of things. So I have up on the screen, for those of you who are watching, this is a document that we filed into this case. Now, I'm going to give a brief background. I've talked about this before in previous episodes, but I have a friend of mine who, let me give you the background story for where he is and with this case and where it's going. I have a friend of mine who, about a year and a half ago, maybe 2 years now, it's been a while, he was attending a Senate committee meeting, one that was open to the public for public comment on a piece of proposed legislation. I'm not going to get into the details of the legislation, but let me just talk about it was a hot, contentious topic at the time. I think it still is to a point. There was an individual who was handing out stickers that multiple people who were there took the stickers and put them on their shirts, their hats, whatever else. And the sticker said, vote yes for this proposed bill. So it's a silent show of support for the bill. Well, this guy here, you can see him up on the screen. His name is Daryl Griggs, and I have no problem outing him out. He was the sergeant at arms, and he took issue with that. And so he wanted to show everybody his power and control. And he went around and said, you got to take that sticker off. You got to take that sticker off. Rightfully so, people started pushing back. They said, why? I have a First Amendment right to speak my mind, and in this case, I'm not even speaking it verbally. It's no different than if I was to wear a shirt that said, vote for this. You're going to make me take my shirt off? Are you going to force me to leave? So people were asking about it, my buddy included. Long story short, this Daryl Griggs went up and talked to this guy, Daniel McKay, who is a Utah state senator. Justice, you might know or have heard of him. He's a real piece of work, I'll tell you what. But he took issue with it too, and so he issued a order. Now, mind you, he's the chair for this committee meeting, and he issued an order that said everybody has to take them off. Now, before I go any further, Brandon, Erica, Justice, is that a power that we delegated to someone to tell us, we the people who, again, all political power is inherent in us? Is that a power we delegated to him to tell us what to do as
No,
it
sir.
relates to our free speech? No? Okay, so we're clear on
Give them the power to help us uphold our rights.
what is the sole purpose of government, Brandon?
To protect our rights.
Protect individual rights.
To protect our rights. That's it. They have no other job as it relates to us, to we the people, other than to protect our rights. Okay.
I'd like to know
Moving on.
how someone out of the legislative authority was able to executively order someone out of the executive branch. That's a separation of power issue too.
It violates the separation of powers. I mean, so again, we're having this discussion. None of us are legal scholars. At least none of us have gone to law school. We don't have a legal degree. And we have all four of us, well, three of us, because Justice is on mute. She's doing things. We have all come to that same conclusion. Now, keep that in the back of your mind as I move forward with what I want to share today.
I concur.
I figured you would. All right. So let's get to where we are. So what happened was my buddy pushed back, said, I want to know the law. What law am I breaking? They wouldn't tell him. At the end of the day, they arrested him, hauled him out of the meeting. Literally, they hauled him out. It took two or three of these state troopers to haul him out of the meeting, issued him a bogus citation. The prosecutor in the case filed a motion to dismiss, said, no, we're not going to prosecute this. That's where we are. So we filed suit. We filed suit against all of these people for deprivations of rights under the color of law, right? So you guys have heard us talk about there's a federal statute, it's called Title 42, 1983, that allows you a cause of action. Now, again, that's important too, so keep that in the back of your mind. What we had is we did this. They filed a bogus motion to dismiss for failure to state a claim, which is 12b-6. So the very first thing we did is we filed this. Now, Brandon, does this say motion on here anywhere?
Mm-mm.
So this says plaintiff's notice to the court, objection, writ for affidavit of commercial liability. I'm going to read this because it's interesting. Okay. To the honorable judge of the court. And again, I'm reading this for those of you who are listening on our podcasts. So for those of you who are watching, bear with me. Plaintiff files this writ for affidavit and notices this court that plaintiff acting pro se objects to counsels for defendants adding to the record anything that is not in affidavit form, sworn to under the penalty of perjury and with full commercial liability. Plaintiff strongly suggests that the named defendants file counter affidavits rebutting the claims made by the plaintiff in his verified complaint. To date, the only facts that have been submitted in the record have been proffered by the plaintiff, supported by affidavits under the penalties of perjury. The defendant's motion to dismiss for failure to state a claim, unsupported by affidavits or depositions, is incomplete because it requests this court to consider facts outside the record which have not been presented in the form required by Rules 12b-6 and 56c. Statements of counsel in their briefs or argument, while enlightening to the court, are not sufficient for purposes of granting a motion to dismiss or summary judgment. Where we heard that, It is well settled law that attorneys' statements and arguments do not constitute facts or evidence before the court. The district court recognized this principle when it instructed the jury that statements and arguments of counsel are not evidence in the case. That was from the 10th Circuit Court of Appeals. Now, that's the circuit court that we fall under here in Utah. Counsels for the defendants are either attorneys or witnesses, but they cannot be both. Okay? Now,
That's great.
in the attorney's 12b-6 motion to dismiss, the attorney makes these statements: that the defendant had legislative immunity, that's the senator, that the defendant troopers had probable cause, that they were entitled to qualified immunity, that they did not arrest the plaintiff, they did not detain the plaintiff, and that the supervisor claims should be dismissed. Okay?
So
Now I ask you real quick. I want to get to your question, Justice, real
Okay.
quick. Are those facts that are being asserted by the attorney?
Well, did he cite any?
They're not under, they weren't in affidavit form.
There you go. So the attorney wrote him on a piece of paper and signed his name to it. And he just said, because he said this is what it is, this is what it is.
It's
Okay?
like the equivalent of him going, nuh-uh, and that's it.
Brandon, Brandon, let me ask you, are those facts that are being asserted by the attorney?
Nope.
They're not facts.
They're not facts. And
So let me just clarify. The attorney is attempting to say that they are facts, when in reality they are not.
that's
Is
true.
that what you're trying to say?
Well, no. Well, here we go again, right? And it's commonplace. I think everybody who's got a case moving through will see that the attorneys are going to speak in absolutes. They're going to allege many things, but it is imperative that you always counter their alleging with facts on the record, right?
There you go.
And this brings up one of your appellate reviews, which is a question of fact. Okay, just for instance, in one of my cases, the attorney states that the property that was taken from me from an unreasonable search and seizure is borderline frivolous, is how you said it, where there's no limitation in the Fourth Amendment of what property constitutes an individual's value of it. There's no limitation there. It could be a piece of bubble.
Crap. I'm waving the BS flag right now. You can't see it, but I'm waving it.
Yeah. And so this desk jockey is going to inform the court that an alligator head stolen from my back porch by Wildlife and Fisheries had no intrinsic value, right? Well, there's no limitation there. He's just speaking off the cuff. Well, you got to hammer him back, right? And I did, of course, and then he's changed his tactic. But again, they'll always, every single time make statements of fact, genuine, materially false statements. So, for example, my last motion against this motion to remand, 4 materially false statements. Well, they won't catch me again doing this early, but all I do is when I start my reply brief is I start off first with every materially false statement. What do I compare that to? Materially false statement 1, 2, 3, and 4. See exhibit H, B, C, D, right? Because what are my exhibits? They're facts before the case.
Yeah, because you supported that with a sworn affidavit.
That's right. That's right. And you got your verification of your complaint, right?
You got to go and look at the rules of evidence. Guys.
That's one of their rules, right?
You're okay. I don't want to cut you off, Brandon, but in the interest of time, I want people to tie these things together, because this is what's important to understand. So I have made it very clear in this objection. The attorney has offered nothing by the way of facts that the court can even consider. Does that make sense? So even though there is a motion to dismiss before the court, nothing that's written in there can be considered by the court, because they are not facts that have been properly presented before the court. But do you think these judges care?
Nope.
Do you guys think they care? Look at my conclusion here. Determination by this court that the defendants have entered nothing on record by testimony, counter affidavits, or depositions, that the rulings and determinations of the United States Supreme Court have precedent over counsel's opinions, and that the motion to dismiss has been filed improperly, justly requires that defendant's motion to dismiss be supported by affidavits in order for this court to consider the facts therein. All I'm asking, submit an affidavit. Put your money where your mouth is. Do you think they did that, Erica?
Probably not.
No, they didn't. Look, I was even nice enough. I wrote out an affidavit for them.
Well, and what you have here is a concerted effort by the attorneys and those the Gestapo agents and
Mhm.
the judges to stop. Okay, there. So it's risk versus reward. Are
It
you
is.
really gonna? Are you really gonna see it all the way through? And so when the magistrate rules with his report and recommendations, the chief judge in the court or the head Article 3 court judge signs off of it. So here's the game, and understand this. When they do that, they've done what's called a judicial act. Okay,
Yep.
they have absolute immunity at that point because it's judicial in nature. However, when you have a magistrate ruling on a case that has Article 3 standing, it is imperative for you to continually call out the Article 3 standing. So, and I'll give somebody an example too in one of my cases. So the magistrate originally was ruling in our case, Miss Winehurst. She has stopped. Why? Because she can't rule on Article 3 standing issues. And so when we hit back at her, the only judge who has ruled is Maurice Hicks. So Maurice Hicks is going to get burned here in the appellate court too, because the cover up is just as bad as the crime. So when the cat gets out the bag, for instance, for your friend here, we know these were criminal violations, violated his First Amendment constitutional right. One, freedom, speech, association, and then his right to attend a public meeting, right? And that we know for a fact that the edict coming from the senator or whoever it was not a lawful order. How can it be a lawful order? There's no crime being committed. There's no reasonably articulated suspicion of criminal activity. There's no objective facts that somebody else within that facility was being harmed. So nonetheless, he had his rights violated. Now, this is an abuse of discretion by the court. So you have your appeal saved, but you have to be willing to go the entire way.
Yes, you do. Yes, you do. So going back to what Brandon is talking about, I now have up on the screen the report and recommendation that was issued by this magistrate judge. Her name is Cecilia M. Romero. You guys have probably heard her before. I am no fan of this woman. You guys know that. The Article 3 judge on this case is actually the Chief District Judge, Robert J. Shelby. So what I have noticed, though, is that 99.9% of the time that the Article 3 judge just goes along with whatever the magistrate says. So here's what she said. All right. Now, you guys know the background story of my buddy. You saw our notice, and we were asking for a commercial writ of affidavit. I'm not going to read this whole document because it's 29 pages long, but there's a lot of things I want to touch on in here. So here's what she says. Having carefully considered the relevant findings, the court finds that oral argument is not necessary and will decide this matter based on the written memorandum. So there's a local rule here. You guys have seen maybe recently Alphonse talking about this. Again, whoever the moving party is has the right to request an oral argument. So in this case here, the defendants filed a motion to dismiss and they just let it sit there. It was a delay tactic. This order, by the way, was issued 8 months. 8 months after everything was done on this motion, just so everybody knows. For the reasons below, the court denies plaintiff's motion for writ, and the undersigned recommends that the court grant defendant's motion to dismiss. Okay? Now remember, Erica's got the hand over her face. Remember, were there any facts lawfully presented before the court from the defendants?
No.
So what in the world is the court recommending that they grant? There's factually nothing there except for our pleading, which at this point has gone unanswered. We could file a motion for summary judgment, which I was talking to my friend about doing, but long story short, I'm just going to leave that where it is. Okay.
Well, did they golf together or something? Like,
they all know each other?
Private conversation that happened behind.
Exactly. This judge, she knows all of the attorneys for the defendants. I guarantee it. They know each other. It's a good old boys club, and we're not part of it because we're PreSe. Right. That's what it is. Okay. I'm going to scroll down here. I'm going to get past the background and everything else here that talks about this, and I'm going to get into the argument section because this this is where your mind is just going to blow. Okay. So here, number 3 is where it says discussion. Plaintiff's official capacity claims against all defendants. All right. Plaintiff brings suit against Senator McKay and Defendant Griggs in both their official and personal capacities, alleging that they acted under the authority of the Utah State Senate, a division of the legislative branch of the state of Utah. Plaintiff also brings suit against the UHP troopers in both their official and personal capacities, alleging they are employed by UHP, which is a division of the Utah Department of Public Safety, a political subdivision of the executive branch. Then she goes on to cite some interesting things I don't think has any relevance, but whatever. In the Supreme Court case Kentucky v. Graham, the Supreme Court explained the difference between personal capacity suits and official capacity suits. Personal capacity suits seek to impose personal liability upon a government official for actions he takes under color of state law, whereas official capacity suits against an officer are generally treated as suits against the governmental entity of which the officer is an agent. When a governmental official is sued in both official and individual capacities for acts performed in each capacity, those acts are treated as a transaction of 2 different legal personages. Remember that. We've talked about this before. An official capacity suit is, in all respects other than name, to be treated as a suit against the entity. So she says, for this reason, plaintiff's official capacity claims against Senator McKay would be treated as claims against his employer, the state of Utah, which plaintiff did not name as a party in this suit. The same is true for plaintiff's official capacity claims against the officer defendants. According to plaintiff, Defendant Griggs was acting as the sergeant at arms on the date of the incident, therefore making his employer the state of Utah. As for the remaining officer defendants, their employer is UHP, or more specifically, the Utah Department of Public Safety, which constitutes an arm of the state of Utah. Thus, plaintiff's official capacity claims against all defendants would have to be brought against the state of Utah, which is not a named party in the suit. Okay, so what's our remedy there, Brandon? We're going to say, what are the courts supposed to do?
Liberally construe.
Okay.
But it's so in Louisiana, it's specific, right? So my statutory process here, and I don't know if you have it there. So my statutory process for suing wildlife and fisheries required that I sue the actual state of Louisiana, and it was not vague or ambiguous. So yeah. I don't know if you have that there. That's the only question when I see this.
No,
so my statutory process, suing the state of Louisiana, I had to file in the 19th JDC, and it actually gives me the entire name, State of Louisiana Wildlife and Fisheries, right? It tells you exactly how to sue that agency. So there's no ambiguity there for how I was supposed to do it.
Well, and see, here in Utah, if you want to sue the state federally, because generally speaking, the state has 11th Amendment immunity, right, from suit against in federal court. But this is why I talk about read your state's Administrative Procedures Act, because as long as they're given notice ahead of time and an opportunity to cure ahead of time, they cannot come back and claim 11th Amendment immunity. So let me give you an example of that. So in my property tax suit, I didn't have to do this. I could have just gone straight and filed my suit. But I went ahead and gave them 60 days opportunity to file a written statement with me, letting me know, hey, we received your claim, we're not going to pay it, or we're going to pay it, or this is what we're going to do. I got zero, zilch, got nothing, nada. Right? Going back to the Three Amigos, do you know what nada means? Yeah, I got nothing. Okay. So I had, according to the statutes, they had 60 days. 60 days came and passed. So now I have a right to file suit. So they cannot come back and claim immunity. Now I guarantee you the stupid attorney is going to try. They're going to be dumb enough to try. But so
I have a question.
Yeah, go ahead.
So is what she's saying in a nutshell, I know the suit was filed against their personal and professional capacities, right? Mm-hmm. So she's saying in a nutshell, because this person was under their title of their job at the time, that their personal capacity is under immunity and can't be sued? Is that what she's saying in a nutshell?
She's just
Sort
saying
of.
you forgot to list somebody on the
Basically what it is, yes, is
list.
so right here where she says, as a result, the undersigned recommends that plaintiff's official capacity claims against all defendants be dismissed without prejudice for failure to state a claim. What she should have said, as a result, the undersigned recommends that plaintiff be allowed to amend his complaint to add the state as a defendant if plaintiff so chooses.
Right.
Otherwise,
say, and they
these
have
claims-
to educate you.
Exactly. Otherwise, these claims should be dismissed without prejudice for failure to state a claim. Okay, that's what she's.
And let's get this too, because this is the importance of reading the statutory process. If people will go pull up my United States Marshals in the federal judge complaint and read the capacities within that are listed. So there's a couple capacities there that people are going to see with a federal judge there, and it's the only listing is the individual capacity. Okay, why did we do that? Because if I listed, as we saw up above, the official and individual capacity, if you list both of them, they're going to claim it as the same entity. However, when you go just individual, what you are claiming is malfeasance, misfeasance, or nonfeasance of office. Okay, that the office itself did not create the cause of action, and especially if you apply that next to the Ku Klux Klan Act of 1871, which is your act to keep ideologues and political hyperpolarized idiots who are following the COVID-19 nonsense and a plethora of other ideas. That's what you're attaching it to. And the only way that I could get the federal judge in any way, shape, or capacity is only in her individual capacity.
Yeah. Yeah. And that's important to know. Like, if you guys have an issue with a judge, which we're all going to have issues with, especially since when, like Brandon talked about earlier, making a ruling on this motion, that's a judicial act. But moving forward, absent of any jurisdiction, like, for example, if a magistrate judge issues a ruling on something they have no jurisdiction over to do, well, now they can be held personally liable and individually liable. So you would sue them individually. So
there's two essential elements. Let's not leave that behind. If you have not read the 1789 Judiciary Act, I advise everybody to start digging into it. But there's two essential elements to that. They have to make a decision absent of all jurisdiction.
Yep.
And the other one is that there must be legal consequences. Okay, so what's legal consequences mean? That means you're actively involved in a case, and subject matter, in personam, territorial, or in rem jurisdiction has already been established, and the judge has the authority to act on the case. So, and let's give a prime example. Administrative orders from a judiciary officer that restricted access to a courtroom. That is not a judicial act.
No,
that is an administrative act, and therefore they lack jurisdiction and they lack legal consequences.
Yep. Good point. So let's talk a little bit more about this magistrate judge's review of the case and what she says here. You guys I hate using the term bear with me, but just as I'm reading through this, I apologize if your head wants to explode. I mean, I know Erica, somebody is just saying Erica is hilarious, like right here, this Jar proprietor.
I'm just involuntarily responding to the ridiculousness of this.
Yeah. Well, I mean, again, because you have common sense, right? And you have to understand that and I'm not saying that this magistrate judge doesn't have common sense. I'm just saying she has been in this world because she was a practicing attorney for I don't know how many years before she became a judge. So all she knows is what she did. And what she did is what the defendant's counsel did. Nothing has changed. So when we're bringing these things to light in these cases, she's like, I've never heard of that before. I don't know what they're talking about. You don't have to support a motion to dismiss with an affidavit. Just get out of here.
Isn't it her job to find truth before making a ruling?
It is. But you're going to see here, I took a different approach on my property tax suit. I'm going to get to that in a minute, but you're going to see here why I did and what's going on. So let's go back here. So now she goes into, all right, so she says, moving forward, the court's only going to consider the personal capacity claims or the individual capacity claims. All right, claims against Senator McKay. She says, plaintiff asserts that because he failed to train, supervise, and or oversee the officer defendants, that he violated plaintiff's rights protected by the 4th, 1st, 5th, 6th, and 14th Amendments. Defendants argue that all claims must be dismissed because the doctrine of legislative immunity acts as an absolute bar. And plaintiff has failed to allege any facts that Senator McKay is actually the supervisor for any of the defendants.
Well, and let's pinpoint this because we're going to go back to what I was discussing earlier about why you want to enter equal protection in all your cases if you can. And what this is going to kick off is your 14th Amendment. And so this has to do with declaratory and injunctive relief. Okay, let's bring this back in. Let's say the absolute bar does apply to the to this senator or whatever. But what has to be done when you enter in the equal protection clauses of the 14th Amendment is now standards of review. You have your rational basis review of the edict. You have your intermediate review of the edict, and then you have your constitutional standard, which is your strict scrutiny standard. And I would suppose that this is what needed to be here for this legend. So what you have here, first off, you've got a separation of the checks and powers, separation of checks and balances. 2, you have an executive officer taking an edict from the legislature and acting unreasonable search and seizure. So I would have actually entered in some type of declaratory and injunctive relief against this legislature, getting an edict from the court that this is a violation.
We did that.
Oh, wow.
We did that. Just hold that thought there, Brandon, because I'm going to read something here that's going to make your mind blow. Okay.
Before you move forward, can you explain what the absolute bar is?
Yeah.
I'm sure I'm not the only one that doesn't know.
So you're going to see stuff all the time about the doctrine of this, the doctrine of that. Like there's the doctrine of qualified immunity, the doctrine of legislative immunity, the doctrine of judicial immunity. Basically what it is it's the Supreme Court or other courts have determined what that means. That's all it is.
So the absolute decision.
So the doctrine of legislative immunity protects a legislature from suit, but only applies to actions taken while they're actively involved in legislating. Now, I found one of the cases that I found in our reply brief to their motion to dismiss was that it protects them in everything except arbitrary and capricious commands that do not affect the public on the whole. Okay, so what does that mean? What that means is a legislature cannot tell a group of people to take off a sticker because it would only apply to the people in that room and not to everyone in the state. Does that make sense?
Total.
But look what this idiot says, okay? To establish personal liability in a 1983 action, it is enough to show that the official acting under color of state law caused the deprivation of a federal right. Now, by the way, there are no such things as federal rights.
Right.
Federally protected rights.
Right.
Get it through your freaking heads, people. And when I say people, I mean these stupid judges. Get it through your freaking head.
And didn't you just say she didn't have common sense?
Major typo. Like if she
As for available defenses, an official in a personal capacity action may, depending on his position, be able to assert personal immunity defenses such as legislative immunity. State and regional legislatures are entitled to absolute immunity from liability under 1983 for their legislative activities. I don't even know what that means.
Well, there it is. This was not a legislative activity.
Now, what did Brandon say about equity, making sure you ask for declaratory injunctive relief? Oh my gosh, did you know we pled that? And look what this.
Yeah.
moron had to say. Because the court here, this is, by the way, this is a footnote. She doesn't even put it in the briefing. She puts it as a footnote. Because the court will only be addressing plaintiff's personal capacity claims, plaintiff's requests for declaratory and injunctive relief against defendants are also subject to dismissal. No, they are not. No, they are not. Sorry, I'm getting really angry here. She says
now let's pull that up. What is that?
I got to go read it. 1983, a plaintiff cannot sue an official in their personal capacity for injunctive or declaratory relief. Bull crap.
Is that why she put it in the fine print, thinking maybe it wouldn't?
Hold on. Don't move. San Juan 41F4.
You're looking at this case, Chilcote v. San Juan County?
Yep.
Okay, while you're looking that up, I'm going to keep reading, Brandon.
Go ahead.
She says, absolute legislative immunity attaches to all actions taken in the sphere of legitimate legislative activity. The doctrine of legislative immunity enables officials to serve the public without fear of personal liability, blah, 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 blah. Does she bother to say what legitimate legislative activity is? No. She says the 10th Circuit has followed the Supreme Court's broad view of legislative immunity, where she says, in this case, the 10th Circuit refused to grant legislative immunity to a county board of commissioners who banned the plaintiff from speaking at all future meetings. The 10th found the board's actions were not related to any legislation or legislative function. Isn't that exactly the case that I just pled here?
It's like exactly the exact case, except it's stickers.
Says, now here's how she turns this around. Unlike the board in Campling, Senator McKay's actions to maintain order during the legislative meeting related to legislation and a legislative function, given that the purpose of the meeting was to listen to debate about a proposed bill. And as plaintiff asserts in the amended complaint, it was Senator McKay's duty to ensure the integrity of the standing committee process by enforcing legislative rules and parliamentary procedure without delay. Guess what? His order to remove a sticker that's protected under the First Amendment did not fall under
Rules and procedure
or a parliamentary procedure.
Nope.
So that quote from that lady is not in this. Is not in here.
So under Chilcote v. San Juan County, it's not there.
41
F.4th1196. It's the 10th Circuit in 2022.
So she quoted prosecutorial immunity. See, and look, guys, this is why you have to go check. So I am
even judges, guys. You have to check these.
Good eye, Brandon. Good eye.
And I'll bring everybody up to speed here. Why every case law must be read. We've caught 2 United States attorneys not only changing canons of construction within quotes of case law, but also quoting case law that has not one order on the record because the entire case was dismissed for failure to pay. Now, let me back up there.
Yes.
The entire case never moved past the payment stage. A PreSe litigant in prison was not allowed to go forward because failure to pay. And I can't remember the actual name of it.
They never litigated his claims, is what Brandon said.
Never litigated his claims, but yet a United States attorney was quoting this case as having precedent. This is vitally important. So right here, I'm in this case, and prosecutors are entitled to absolute immunity for their decisions. And here we go again. Prosecutor is absolutely immune when functioning within the scope of his duties and initiating and pursuing criminal prosecution. And it's over and over. So I control F, right? She said legislative, right? So let's go to the only piece of 2 comments of legislative in here. Here, the county commission is both the legislative and executive body. So we're actually talking about a municipality here. And no one has ever doubted, for instance, that a municipality may be liable under 1983 for a single decision by its properly constituted legislative body. The only two instances in this entire order from the 10th Circuit 41 F 4th 1196 that mentions legislative.
Yeah.
I wonder if she put it in the footnote. It was a total stretch. She was hoping you wouldn't catch it or something.
Yeah.
And that's why it's not in the body of the document.
Right.
That's right.
That's why she put, because she's not, again, she may be clueless, but she's not an idiot.
And that's why it took her 8 months so that she could find that super obscure thing and then twist it a little bit to try to trick you.
And this gets back to what I'm talking about. So this is, so you can actually, you'll have the de novo standard here also. So you're going to have the de novo standard. So your standard of review to the appellate court, de novo, questions of fact, and then abuse of discretion. You'll have all three.
So these judges are supposed to be held to the highest standards because they're the ones that make the decisions on people's lives.
Correct.
So
Correct.
what recourse is there to hold her to the standard, or, you know, combat that she acted ignorantly with?
Well, remember,
So-
we'll go back to the beginning in the opening statement that I had. We are fighting on ideological grounds.
Right.
They are protecting their own conscience. And this, nothing, absolutely nothing presented to you in any of their citations, any of their conclusions, or any of their novel legal theories should be accepted. You must read through it all, and I guarantee you, if you are diligent and you actually go through every damn thing they list, you're going to find many things just like what this claim here. And James is right. There's a reason she put it in the footnotes and she added hypotheses, right? Because that's an addition to the text. Well, let's go back to our grammar rules, right? She added to the text.
That's not fact. It's not precedent. It's her freaking opinion, which carries about as much water as a cup that has 50 holes in it.
Mm-hmm.
Okay, that's what that means. And Brandon's not wrong. So, Justice, to answer your question, or was it Erica? What is our recourse here? The rules stipulate we have 14 days to file an objection to the magistrate's recommendation, report and recommendation. We have to cite with particularity all of the problems with this report. Now, I've already found 4 that I could cite. We should be given an opportunity to amend. The magistrate judge has falsely assumed that they have these immunities when when the law states otherwise, all of these things, okay? And I'm not even done with the document here, you guys. But you're going to see this is exactly the madness that is here. And why do you think it is that these magistrate judges, and not even just the magistrate judges, even these district judges, why do they scrutinize pro se pleadings like they do? And the answer is actually very simple. And it goes back to something you guys may have all heard before. But there is nothing that an attorney, and I would dare say the court, fears more than a well-educated pro se litigant, because they know they can hold their feet to the fire. They know they can do like what Brandon is doing and potentially getting a case to the United States Supreme Court. I mean, do you know how unprecedented that is, that you can get an individual who can actually articulate the law and be able to move the case and show the errors of every single court below it? I mean, we're finally starting to see things turning around the way they should at some of these courts of appeals, but definitely at the Supreme Court, even with morons like Jackson Brown on the bench. She couldn't even tie her shoes without help. So I'm sorry. I don't mean that, you guys. Please don't.
No, you're right, James. Every single time they're responding to these things, they're just keeping their fingers crossed. Like, I hope they don't catch me. I hope they don't.
Right.
No,
right.
I totally know what I'm talking about, and that I really screwed that up.
Well, and you're going to see. Oh, sorry. Go ahead, Justice.
Or put these things in there to just continue the rabbit tail chase.
Yeah.
And stretch it out. If you find it, then it just, delays it more and delays it more.
Yeah, they don't want to disrupt the status quo. Remember, like I said, This magistrate judge, she was a practicing attorney for I don't know how many years before she became a judge. This is all she knows. This is all she knows how to do. And you're going to see why, again, I keep going back to my property tax suit. I'm going to bring that up on the screen here in a little bit and show you why I chose to go in a different direction, but you're going to see. Okay, let's talk about this. She says plaintiff's 1983 claims. This is Title 42, 1983, right? Which gives you an option to sue for a deprivation of a federally protected right. She says that plaintiff asserts that the officer defendants violated his right to be free of unreasonable searches and seizures protected by and guaranteed by the Fourth Amendment, which is correct, when they falsely arrested him without probable cause. Defendants argue that plaintiff's false arrest claim should be dismissed because it fails both prongs of the qualified immunity standard. Now remember, did the defendants submit any affidavits in support of their motion to dismiss?
No.
So this line right here shouldn't even be here. Can't even consider it, but she did it anyway. The court begins by addressing the first prong of qualified immunity analysis. Again, can't consider it because they're freaking out. The motion to dismiss had no affidavits, but she's just kicking that under the can like it doesn't matter. So is she acting with judicial immunity at this point, or is she just going off on the rails? I would dare say, I would make the argument she's gone off the freaking rails. But let's read it anyway. Under the first prong, plaintiff must sufficiently plead that the officer defendants violated his federal statutory or constitutional right. Okay, again, my head is going to explode. Erica, help me out here.
I thought you did a pretty good job there.
We do not have constitutional rights, people. Okay, got that off my chest. Oh, I feel so much better. We don't have constitutional rights. We never did.
Constitutionally secured rights.
Constitutionally secured, constitutionally protected, whatever you want to call them.
Maybe she really doesn't know, because that's twice now that she's like.
Mm-hmm.
Well, I
am willing to bet. I am willing to bet that if you go up, if you find her on the street and you say, "Hey, what form of government do we have here in the United States?" she'd come back and say, "A democracy."
Yeah.
Yeah.
Yeah. Challenger, that's my school. Anyway.
It just goes to show you how political even getting into office is, because if she is this ignorant, how did she become a judge, right? If she can't even do the law properly.
Well, again, magistrate judges are not appointed by the president. They're appointed by the other judges on the courts. And so, again, the other judges have interaction with attorneys. They're like, hey, we like this attorney. Let's nominate them as a magistrate judge. And there you go. That's how they get
big club. Yep.
Okay. So moving on, plaintiff asserts that the officer defendants violated his rights under the Fourth Amendment because they arrested him without probable cause. The Fourth Amendment guarantees the right of the people to be secure in the person's blah, 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 blah. An arrest without probable cause that a crime has been committed violates the Fourth Amendment. Duh. That said, when an officer has probable cause to believe a person committed even a minor crime in his presence, the arrest is constitutionally reasonable. Okay. Probable cause requires reasonable, trustworthy information that would lead a reasonable officer to believe that the person about to be arrested has committed or is about to commit a crime. Okay, I don't have any argument with any of that.
Right.
The subjective mindset of the arresting officer does not matter. Rather, we ask whether the totality of the circumstances viewed objectively justifies the arrest. For the following reasons, the court finds that plaintiff has not sufficiently pled that the officer defendants violated his Fourth Amendment rights. Okay, I'm going to stop right there because there is a constitutionally protected provision in every state constitution that if an arrest is made without a warrant, what must happen, Brandon?
Affidavit of probable cause.
Okay, affidavit of probable cause. Where must the arrestee be taken? Immediately and without unnecessary.
Before the magistrate, immediately.
To a magistrate. The magistrate would determine whether that officer had probable cause to effect the arrest, correct?
Correct.
Well, and what I don't understand about this particular case right here, that he was charged correctly, and then the prosecution motion to dismiss it out right there.
Yeah,
that evidence right there, the motion to dismiss by the prosecuting attorney, is facts before the court that he was unreasonably searched and seized and had an arrest that was not based on objective facts that would lead to a suspicion of criminal activity. So the facts are already within the case.
Yeah, it already stands as truth and fact before the court, right? At that point.
Yes.
Yes. Again,
Yes.
you guys, I mean, that's why I'm saying it makes your head explode when you read this. I mean, it gets even worse, okay? She says, as alleged in the amended complaint, plaintiff was arrested and issued a citation for disrupting a public meeting as prohibited by Utah Code annotated 769103, which states a person violates this section if intending to prevent or disrupt a lawful meeting, he obstructs or interferes with the meeting.
The cop did that.
You have to prove intent, just like you would,
You
right?
do.
Right.
She says the allegations in the amended complaint indicate that the plaintiff refused to take off his stickers. That's not true. He did. He took them off. We never said he didn't. He took them off, even after being told repeatedly that the removal of the stickers was necessary based on the rules and procedures of the meeting. Okay, again, there were no rules or procedures of the meeting that governed that they had to take the stickers off, and we've made that very clear in our amended
Just make
complaint.
stuff up.
She goes on. McKay made it clear to everyone, including the plaintiff, that any demonstrations of how one feels about the bill were not allowed, stickers included. Again, that's not an authority that McKay has. He can say whatever. Matter of fact, I have him on video saying you can flip off the chair if you want, but you just can't flip off the other members of the committee. So it's okay for me to flip off the chair, but I can't wear a sticker in silent support for a bill. Makes a lot of sense. She says McKay proceeded to put the meeting in recess because there were individuals in the audience, including plaintiff, who were not following the rules. She then states plaintiff admits that the rule being referenced is 769103. No, I did not. That's not the rule I'm talking about. It's Utah legislative rule, which prohibits signage and banners in the House gallery only. Okay, so you guys know what the House gallery is? That's like where the Utah House of Representatives or any state's House of Representatives, there's a gallery that you can watch. You can't dangle signs up there to have people vote for what you want.
Right.
But did I say we were, or did the amended complaint ever say we were in the House gallery? No.
No.
We were in a committee meeting, in a closed committee meeting. There is no rule that prohibits anything of the sort in a committee meeting. He just made it up off his cuff. Okay. And I have it on video, evidence that we submitted that the defendant officer says whatever the chair says is as good as law. Really? Yes. If you go back and look at the complaint, I've got links to all the videos on a public website. You can watch them and you can see, yeah, whatever the chair says, that has the full force and effect as law. Oh, okay. So we are now living under a tyrannical
Total
government.
tyranny.
They just
This
get to
is
make
not a
stuff
republic.
up.
This is no longer a republic.
It's crazy.
Yeah. Okay. So she cites the wrong rule. This is the Utah Criminal Code of disrupting a meeting. This is not the rule that prohibits anything because there isn't one. She then says, Plaintiff Griggs asked plaintiff to comply. Plaintiff gave defendant Griggs one of the stickers. Wait a minute. I thought she said he refused to take them off. I'm confused. Plaintiff gave Griggs one of the stickers stating he wanted to keep the other, but he would turn it over, i.e. make it not visible. What's wrong with that? Plaintiff then asked if it was true that whatever the committee chair says was the same as law. There's where it is. To which defendant Griggs replied, if you want to argue with me, I'm going to have you come out. So he doesn't give an answer. Plaintiff replied by saying he just wanted to know what the law he was violating. He has a right to know that, right? Plaintiff then questioned defendant Griggs about a Ukrainian flag that was on his lapel. Plaintiff alleges
ideologues, and you find it everywhere. You're challenging their ideology, and
Plaintiff alleges that defendant Griggs appeared to take issue with this questioning and eventually motioned to one of the defendant troopers to have him hauled out of there.
That's where it became the pissing war, right?
Yep.
There, right?
Plaintiff was then told he had disrupted the meeting and his could choose to be arrested or leave on his own accord. Plaintiff did not leave, but continued to assert that he complied by putting the stickers away. And maybe it says right here, nope. By the way, he also asserted that the meeting was in recess. So there was no meeting that he could have disrupted.
So interesting.
How do you disrupt a meeting that's in recess?
Can you file assault charges as well?
We did, actually. He did file criminal complaints, verified criminal complaints, but guess what? They've fallen on deaf ears.
Yeah.
At this point, plaintiff was informed he was under arrest and then forcibly removed from the meeting. For plaintiffs to state a plausible claim under the Fourth Amendment, he must allege facts from which the court may reasonably infer the officer or defendants lacked probable cause. I just told you how they lacked probable cause. Because they never took him before a magistrate for an affidavit of probable cause or for a determination of probable cause. So just because you, magistrate judge, based on what I wrote in my complaint, say they have no, they do not. Furthermore, there are no facts from the defendants to counter any of the facts that I put before the court.
And just for you to know, in the private chat, James, I don't know if y'all can transfer that, but all that right there is from the case law that she quoted, Boucher 2020 Westlaw 6899496, and that substantiates what we just said about the affidavit of a probable cause and what is needed to not violate the Fourth Amendment. But that's from the case law that she quoted, by the way, that she omitted these facts. Yeah. I just want to show, and look, and I'm just showing people that they will cherry pick what they want from case law and skip over the empirical evidence within that particular case law, right? You have to be diligent in when you're going through what they're quoting, because they are fork-tongued liars, and they are critical. They are critical theorists taught in Marxian theological schools, and they despise the rule of law.
Yep.
Despise it.
Yeah. So again, all of these things were
within the Republic. Like,
exactly.
They really aren't. They're pretending. And then when we try to bring up points of being like, hey, this is what it's supposed to be like, they're like,
Yeah, you just have to know and understand you're fighting a two-front battle when you bring cases into any, I would dare say, any court right now. It's not just federal court, it's any court. You're fighting a two-front battle. You're fighting the battle against your adversary and whatever crooked attorney they have, and you're fighting a battle against the judge because they're of the same mindset.
And we'll get back into this. Just one point on this too. Remember, you're fighting up against snobs too. And what do I mean by that? These intellectual, self-proclaimed, enlightened ones of the bar and everything else, they're protecting something too. And you must recognize that self-interest is always part of the equation here. Remember, you're knocking on the door as a pro se. And when you come knocking on that door and you're not pushing birth certificates or, secret trust and things of that nature, you actually intend to use the rule of law and the rules of civil procedure and the rules of evidence moving forward. Just understand you are engaging into their personal space, and they don't like it. Remember, this is supposed to be hidden knowledge. They've captured the Bar Association through critical legal theory, and now here comes Johnny Sixpack and Susie Tutu up into their courts, right? And that's what they think they are. They think they're their courts, and they're not. They're ours.
Yeah. You're going to see again how asinine this analysis of the complaint is and her conclusions of that. Because again, the facts show they did not have probable cause because guess what? I cited in the complaint the Utah statute that requires when an officer makes an arrest without a warrant, they are to be taken without unnecessary delay to the nearest magistrate. I cited that in the amended complaint. Guess what? She never makes any mention of. Doesn't make any mention of that fact. Okay. Matter of fact, she pours gasoline on it and intends to light it on fire because she says right here, Plaintiff's allegation that the officer defendants violated his Fourth Amendment rights by falsely arresting him without probable cause is a conclusory statement. She would be correct if that's all we said. But we didn't say that. We said that they failed to do their duty as is required by the law that they're required to follow.
Well, read that sentence again, James, and see if you can pick out the forked tongue speak. She starts it off, plaintiff's allegation. Okay. And then she ends with a conclusory statement. No, when you allege something, guess what you've done? You've alleged that this happens. This is why we have the discovery process. So it's not a conclusory statement. This is asinine that she would even write that.
I know. She says, consequently, the court disregards this statement and looks to the remaining factual allegations to determine if plaintiff stated a plausible claim. Disregarding these conclusory statements and looking into the remaining factual allegation, the court finds the plaintiff has failed to nudge his Fourth Amendment claim across the line from conceivable or speculative to plausible. The facts as alleged in the complaint would lead a reasonable officer to believe that plaintiff was committing or had committed a crime during the meeting. What crime?
Yeah.
I am sorry. I'm getting very emotional reading
this.
No.
I'm with you. This is crazy.
If I was in court, I would be under arrest for contempt of court right now because I go back to that scene from Billy Madison where the guy was like, those incoherent and rambling statements, we are now dumber for having heard it. That's where I feel like this is going. She says more specifically, the facts as alleged by plaintiff would lead a reasonable officer to believe that plaintiff was obstructing or interfering with the meeting in violation of this code by wearing the stickers, refusing to take off the stickers, and insistently demanding to be told what law he was breaking. Do we not have a right to know what law we are breaking?
We absolutely do.
Yes, we do. The amended complaint also fails under the second prong of qualified immunity analysis. By the way, just a little footnote here. The Supreme Court has succinctly stated that a motion to dismiss is the wrong document to assert qualified immunity because it requires discovery.
Yep.
Just so you guys know. Under the second prong, plaintiff must plead sufficient facts to show that the unlawfulness of the officer's conduct was clearly established at the time. Okay, I don't even want to read that because it's just going to make.
Well, this report and recommendation is just as bad as Gary's, where we ended up at 5,100 words or thereabout in blatant abuse of discretion by the magistrate judge in their report and recommendation, and it's the same thing same thing. So this judge knows as a magistrate that she doesn't have judicial capacity, but she can put this garbage out there, right?
Yeah.
She can put this garbage out there and act as if she's actually followed any of the processes, and she has not. This is egregious. This is very bad.
Can you believe this? And it gets worse. Okay, and for the sake of time, we're coming up on an hour and a half. I don't want to go through all of this, but I did post this in the Affidavits 101 chat group. It's in Alphonse's group. Guys, go look at it and read it. This is what we're up against. So again, there is a little footnote here, and I'm sorry, I'm scrolling through this pretty quick. There's a footnote right here where she says the plaintiff's charges were dropped and never adjudicated. She says that plaintiff's charges were dropped and never adjudicated is not evidence that the officer defendants violated the Fourth Amendment.
It actually is.
Then what the hell is it? At this stage of litigation, the question is not if plaintiff actually committed a crime. The question is if an objectively reasonable officer would have sufficient reason to believe that plaintiff was committing or had committed a crime. Guess what I have on recording? I have one of the officers saying, why did we arrest this guy? Was it because of his shirt? It's because he was wearing a We the People shirt. What did we arrest him for? I have evidence of them talking what they're going to charge him with. So do you mean to tell me that someone can slap handcuffs on someone, haul them off to a room, keep them there for 45 minutes while you two determine which law applies. And you want to tell me you had probable cause to effect that arrest?
Yeah, it was objectively reasonable that the officer had sufficient evidence that he had committed a crime.
Yeah,
what crime was it again?
Exactly. Hey, what did we arrest this guy for? I don't remember. Yeah, exactly. Okay, I'm gonna skip through some of these other things here. The second claim is the First and 14th Amendments. Again, I'm getting to the point where my head's gonna explode if I keep going further.
Well, it's not going to get better, and
No.
I'll explain. This is so either somebody is going to do the real findings of fact and conclusions of law correctly by originalist and textualist ways, or you're going to get this. So, people, this is novel legal theories. This is what this is. This is what this is. This is critical legal theory. And it's Marx in its thought processes, right? And when I say that, I don't mean it emptily. You have to understand that this woman, or even a man in instance, have gone to higher education within the last 20 to 30 years, probably.
They've been indoctrinated.
They've been indoctrinated. And they think it is their duty to protect the executive branch. And also make excuses for their own ideological choices. So if I had to guess, if I were a betting man, I would say this woman is a branch COVIDian. I'm going to tell you, if you go find it, you're going to see her walking around with a mask and probably on Twitter or somewhere else, happily with her vaccine patch.
She has a duty to protect her brothers and sisters who are part of it.
Comrade! That's what it's like. I mean, I'm making a joke, you guys, but my gosh, every single day that goes by, it never ceases to amaze me how closer we're getting to what Mother Russia was, or what, I mean, this is what blows your mind when you have the leader of a former communist nation making more sense than a leader of a supposed republic. That's what blows your mind.
They'll tell you it's a democracy. They're not even lying about it anymore. They're not even trying to pretend that it's the republic anymore.
Yeah. So this is what I wanted to talk to you guys about. Was this is what we're up against, and what frustrates me at the federal court is it's more paperwork. I shouldn't have to reply to this nonsense. But guess what? If I don't reply to it, I can't object to it. And if I don't object to it, I can't appeal it. That's how asinine this is. So now you have to spend the time to write up a reply to point out all of the errors and mistakes that they made, just so that the district judge can say, oh, that's great, but we're still going to dismiss the case anyway. Because again, they're basically saying, call us out on it.
Well, and what I would do, James, and just to make sure that you do it, like I was pulling up these case laws as you were going through them. Yeah. I would use the exact same ones, but in full context. Okay.
Yeah.
And I would go through there and make my memorandum. Magistrate quoted this case, but she conveniently left out the actual elements needed. Right. And over again, that's what we've done every time. And yes, it's an attempt to wear out the saints. Folks, I'm not going to make any excuses. We are in dire straits in that for 60 some odd years, the American public has been asleep at the wheel. And guess what has happened? The tyrants and ideologues have taken over. That's just that's the truth. You're not going to jump right through all these hoops. But if you use morals and values and don't dissuade from your principles, at the end of the day, everything's going to be okay.
Yep. So I was making hints at, my property tax suit that I just filed. And I said I was choosing to take a different direction because, and I talked to Brandon about this earlier this week, because I've been doing a lot of research and finding some interesting rulings surrounding these things. And what I had noticed was litigants, not only pro se, but just litigants in general, that are moving under a statutory cause of action, meaning Title 42, 1983, or any other type of act of Congress, inadvertently waive constitutionally guarantees by choosing to do that. And they probably didn't even know it. So as I was looking at my suit, I sat back and I thought, okay, I wonder if there's a different approach that I can take. One where I just essentially pull that rug right out from underneath them at the very beginning, as opposed to going through all this song and dance. So when I filed my suit, I actually have this suit written up in 2 copies. I have one where it's very similar to the one that Alphonse filed, where I have Title 42, 1983, all these other statutes I'm moving under. And then I have this, a suit at common law for compensatory damages, injunctive and declaratory relief, and demand for trial by jury. Now, there is no common law injunctive or declaratory relief. That is codified in statutory law, which is right here, 28 U.S.C. 2202. But guess what? Causes of action under that statute cannot be dismissed for stating failure to state a claim for which relief can be granted.
That's right.
I don't care what that stupid magistrate said. So I said, all right, here's what I'm going to do. I'm going to bring this suit for deprivations of constitutionally secured rights. Again, I got it right. She didn't. Under color of authority and color of law, under authority of the 7th Amendment to the United States Constitution and Article 1, Section 11 of the Utah Constitution, which is basically the equivalent of my Utah Constitution to the 7th Amendment. And then I talked about what I said before. Whereas all political power is inherent in the people, and all free governments are founded on their authority for their equal protection and benefit. I bring one of these, I said, one of the sovereign people, the Union State of Utah, brings this verified suit at common law under authority of the 7th Amendment. Okay, I'm going to stop sharing this because, again, I posted this in the group. You guys can all read it. But you know what I find is interesting? Not even 3 hours after I filed this suit, I got an order from the court. And you know what that order was? Let me pull it up here in my email because I don't want to cite it incorrectly. It was, where is it? This one? It was an order to propose a schedule. Brandon, have you ever gotten one of those orders in any of your cases?
Yep. 26F, right?
Yep.
Yep.
What's interesting is of the other 4 cases that I've been involved with, never got one of those orders. Nothing ever happened.
Yeah, we've gotten it in 2 of them. However, the attorneys fight the actual scheduling conference. We've gone to one, and again, let me tell people. So I've got motions to dismiss everywhere. They're just sitting there, right? And the opposing counsel has failed to litigate it. One of the 26Fs were motion to stay by the judge. That's going to be Daniel Jordan, who is motion to stay all discovery. And we're just sitting here for 5 months. What can we do, folks? So, as a matter of fact, Gary got his on the original City of Central. As soon as it was filed, the first thing that was filed into the case was the 26F. Yeah.
Yep. So, and I'm just reading between the lines here. And what I'm getting, and maybe my assertion of this is way off in left field, and if it is, Brandon, go ahead and tell me. But my interpretation of that is that the judge has at least read the complaint or looked through it and said, this guy's got a claim for relief. I'm going to nip this in the butt right now. I'm going to make these parties get a scheduling order put together. So this isn't being dragged along unnecessarily. That's just what I read from that. Doesn't mean you're not still going to get a motion to dismiss, because again, that's what all of these stupid attorneys do. Throw crap up against the wall and hope it sticks. But it's our job to hold it to fire.
Another thing that's going to happen too is when you start initial discovery, you try to have this conference, right? And you try to initiate discovery. Discovery is literally where these cases are going to die, folks. Every single one of them. That's why you see such an effort to motion to dismiss it out. Once you get to discovery, especially on 90% of our cases, there's nothing they can do. There's no defense of the indefensible position. So, well, with that said, two of the cases we tried to do the discovery conference, and the opposing attorney instantly puts in something that he's not ready for discovery, and then of course the magistrate's recommendations on one of them went in that we don't need discovery. Yeah, you do. If you factually and facially have pled sufficiently, which we have. So let's define the two. Factually means affidavits, verifications, and exhibits which substantiate your factual claims. Facially is your allegings, right? How it happened subjectively that you need to prove through the discovery process. Yep. But once you meet those,
stories, depositions, yes,
that's right. So the only way they could infer reasonably that to the plaintiff on every single one of our cases, by the way, every single one of our cases, the essential elements are pled for each statutory cause of action. The essential elements are pled for every single one of my common law violations. All those essential elements are pled, right, with facts and evidence and facial plausibility. And look, it's not just factual plausibility; it's factual and facial. That's the plausibility standard, which is another thing that your magistrate left out, by the way, because but you have these, and then they're supposed to be liberally construed for the pro se plaintiff. But guess what? Guess what we are finding? They are going to go through you with a fine tooth comb.
They're not. Not to. I want to get to this question on the screen here from Bible Book Club, but not to get off into left field. Whoops, sorry, Justice. I know you're doing that. I had another case, which I knew was just going to go, basically just going to go to die. And in my local court rules, there's a rule there that says if you're going to submit a motion for leave to amend, you have to submit the proposed amended complaint, and you're supposed to redline it. There's a little footnote to that says, unless you're pro se, then you don't have to do that. So guess what this same stupid magistrate judge did in that report and recommendation? She cited the fact that we didn't submit it redline, but she omitted the fact that the rules state that the pro ses don't have to.
Yeah.
I mean, it never ends. But Bible Book Club asks a really good question. Constitutional guarantees are waived in a 1983 action. Where are you getting this information? I want to be very clear. I never said that they're waived. What I am saying is when you're choosing to move, if your cause of action is a statutory cause of action, you're choosing to move under rights and privileges that are granted to you by Congress. You're not choosing to move under causes of action that are granted to you by your creator. Does that make sense? I want to make sure we're very clear on that. I'm not saying that those are waived. What I'm saying is the courts look at them differently as opposed to, hey, wait a second. This guy is a public servant. This guy swore an oath to protect my rights. This guy violated that oath and broke my rights. He has now a breach of fiduciary duty to me. That's a common law cause of action. You can plead that all day long, and there's nothing that anybody in Congress can do about it. All I'm saying is Louisiana. So all I'm saying is that Congress, they had the right idea, because all of these things have been in place since the post-Civil War. And it's like Brandon talked about. You had this democratic socialist organization. They were not a racist organization. They were hell-bent on changing our republic to a socialist Marxist government, and they still are. And so Congress had the right idea we're like, well, hey, well, let's go ahead and give this statutory right to people. But guess what? According to the Constitution, can Congress give anything to people that they are not lawfully delegated from we the people? So for those of you who are watching, you can see Erica giving you that no, 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 no. She's shaking her head no. So this is where Congress has lost it. They take the approach of, well, the Constitution doesn't say we can't do this. No, that's not, this is a contract. And the terms of the contract are listed and spelled out. And if it's not expressly listed in the contract, you are prohibited from doing so. Matter of fact, each one of your state's constitution is going to find something along the lines that says the provisions in this constitution are both prohibitory and mandatory. What that means is if it's not written here, you can't do it. And if you do it anyway, that law is null and void. But see, the problem we have is, like Brandon says, we have this private member association, the Bar Association, that has taken over our beautiful justice system and has perverted it, and they have convoluted all of these wonderful, brilliant minds to believe that if it's written on a piece of paper, voted on by all these people, signed by some guy sitting in a White House, then it is gospel truth. That is not true.
I believe it's intentional weaponization.
Oh yeah, well that's you're right. That's what it is. So when you weaponize government to inflict totalitarian authoritative measures, that's exactly what it is. That the government has been weaponized in the modern administrative state, which was what Woodrow Wilson viewed, is a rule by unelected experts, right? And that is the intention. That's what we saw, where these unelected bureaucrats who are intellectual geniuses, no more than the peasant class, right? It's really what is called a technocracy.
Mm-hmm.
So Just Me says the ABA, which is the American Bar Association, just created a bipartisan task force to educate Americans about our democracy. Good luck with that. We don't live in a democracy. We never have, and we never will. So anyway, so guys, we're coming up on an hour and 45 minutes. I do want to thank my guest, Brandon, for being here. Thanks, buddy. It's always good to have you on the show. Really appreciate your insight. I really just, again, wanted to go over, I mean, you guys see why when I first read this report, I'm like, you have got to be, she actually wrote this and signed her name to it. Mm-hmm. So we have a lot of work to do as far as that goes for that particular case. But I'm just telling you guys, be prepared. You've got to be in this for the long haul. You have to, because eventually you're going to get to an adult in the room that's going to go, where are you getting this information? Not only are you misquoting what we said, right, because she was quoting opinions from the 10th Circuit Court of Appeals, not only are you misquoting what we said, it's completely irrelevant to the case at hand. So stick to your principles, stick to your guns. You guys are going to be just fine. As always, ask your questions, drop them in the Telegram chat. And I apologize ahead of time for those of you who only see us on YouTube or any of these others. I don't get into our YouTube much, and I don't see the comments on our videos. I need to do a better job of that, and I will. You know, Justice has been doing a great job of sending me things when you guys do that stuff. So we really appreciate all of you who watch us and support us. Thank you so much. As you guys know, Justice has been advertising some new swag. She wants to put some constitutional amendments on some of our shirts. So thank you to those of you who are looking at those or buying those. I appreciate you all. But as usual, like the video, share it with your friends, subscribe to our videos, subscribe to our channels on the podcasts, wherever you might be finding us. Really helps us get the word out. And I feel so blessed. I mean, we started this at the end of January. Here we are in August, and we are just rocking and rolling, you guys. And it's all because of you. So thank all of you. Thank you to Justice and Erica, my beautiful co-hosts, for helping out. And as always, thanks for Brandon having him on as a guest. So with that, you guys, I'm going to sign off. Erica, Justice, Brandon, any closing thoughts you guys want to leave us with?
Have a good week, everybody.
I'm going to say keep praying, people.
Short and sweet to the point. I love it. Brandon, anything you want to say before we sign off?
thank you for having me, and look forward to the next time.
Awesome. Thank you, guys. Everybody, God bless you all. We love you, like I said before. Stand up for what's right. Stand up for your principles. God will protect you. We know it. With that, we're going to sign off till next time. Thanks, everyone.
Bye, everybody.
Bye, Brandon.
Bye.